Okay, well, we're a couple minutes after, so we're going to get started. Again, appreciate everybody for tuning in tonight. We're going to talk for about 15 or 20 minutes on the new FTC rule that came out, and then turn it over to questions for you all. My name is Kyle Claussen. I'm the CEO of Resolve and a healthcare attorney. We've got a few other attorneys here on tonight, and so I'll let you guys introduce yourselves quickly, and then we'll get going. Lauren, you want to start? Or Bryce,
Sure.
either?
Yep. Hi, everybody. Lauren Kaufman here. I'm another attorney at Resolve, a healthcare attorney, and looking forward to discussing.
Bryce Krieger here, same as Lauren. Yep, healthcare attorney as well.
And I'm Zach Baer. I'm another attorney here with Resolve.
Okay, sounds great. Well, we're going to start this like any good attorney would with a disclaimer. We are not giving you specific legal advice tonight. All of the opinions and discussions that we're having are educational only. If you have specific questions, please, you need to reach out to a healthcare attorney on this. There's a lot of nuance in the rule, things we're going to go through tonight for you. There's notice provisions, there's timing of this thing, which it's not effective yet, that we're going to touch on as well. So again, this is for educational purposes only. So with that, Bryce, do you want to start out and just talk to us for a minute on why we're even here, what non-competes are, features of them, etc.?
Yeah, absolutely. So yeah, basis for why we're here, right? What are non-competes? So for purposes of this discussion, we're really going to be focusing more so on restrictions on your ability to practice or compete post-termination of the agreement, and that's that first element, the time frame on these non-competes. Generally, right, 1 to 2 years is something that we see pretty typically. Restricted areas can be something as simple as a mileage radius, or maybe it's facility based, maybe a county, right? As scope for our purposes, typically, again, practice of medicine, any way of competing with the business of the employer. Exclusions are not going to be as much discussed tonight. That's going to be more so of, hey, what happens if this agreement expires, right? Is it only if I walk away, or is it if the employer were to terminate me? But that's generally what we'll be talking about is post-termination restrictions on your ability to compete or provide services.
Yeah, I appreciate that. And I think one important thing to note is that, from our vantage point, I would say 90 to 95% of the agreements that we look at on an annual basis have a non-compete in them. So this is a trend of physicians becoming employed, right, and not in private practice and being practice owners. But it's also, most states will allow these, right, prior to the FTC's rule. And so for everybody that's under contract right now, a major issue and potentially, major changes that are coming. So Zach, do you want to fill us in a little bit on just who the FTC is and give us some of the background information on that?
Yeah, sure. So the FTC, the Federal Trade Commission, it was created in 1914, and its purpose was to prevent unfair methods of competition in commerce as part of the battle to bust the trust. Over the years, Congress has given the FTC greater authority to police these anti-competitive practices, such as in 1938, Congress passed this broad prohibition against unfair and deceptive acts or practices. So the FTC authority, Section 6G gives the FTC the authority to make rules and regulations for the purpose of carrying out the provisions under the FTC Act, which includes the prohibition of unfair methods of competition. And that kind of brings us to this new FTC rule, which states that it is an unfair method of competition for a person to enter into or attempt to enter into a non-compete clause, enforce or attempt to enforce a non-compete clause, or represent that the worker is subject to a non-compete clause. So it encompasses new, current, and prior agreements.
And I think that's really important. The fact that it's applying not only to future or prospective agreements, but also that it's retroactive is one of the reasons that it's getting, I think, a lot of attention and potential challenges to that, which we'll talk about here in a minute. But but it's a little bit unprecedented, right? For an agency to come out and attack contracts between private parties that have been in effect sometimes for 4 or 5 years at a time. So Zach, let's talk about a little bit of when this is going to be effective.
Yeah, so the rule is going to become effective 120 days after publication in the Federal Register, which is set to be May 7th of this year. So in 5 days from now. That would put an effective date of September 4th, 2024. This date is subject to pending litigation. It could be changed due to this pending litigation, and there's already several legal challenges that have been brought against this FTC rule. The Chamber of Commerce, ATS Tree Services, Ryan LLC, a Dallas-based tax services provider, they've all brought litigation against this new rule. So this new rule, it could be effective September 4th, but it kind of depends. It's variable at this point in time.
Yeah, we're gonna close with one of the last slides on kind of our advice for physicians. But I think the overarching tone on this slide is that nothing's effective today, right? And I think most of you are aware of that, but certainly September 4th is coming, but you need to stay tuned for what that's going to look like with the litigation and if that deadline changes. So I think it's also important to note that the FTC governs all business, right? It's not just healthcare. And so there's been some question on whether or not the FTC meant this to apply to healthcare. Lauren, I'd like you to just touch on, what some of the things the FTC said and whether they think it's applicable to physicians specifically.
Yeah, great. And, short answer as to whether or not this is meant for healthcare is yes. As Kyle said, applicable to many industries and maybe more industries than we think like to use non-competes and the FTC acknowledged that in the rule itself. But throughout the rule, over 150 different references to providers, physicians, the healthcare industry, and they took time out to specifically discuss the healthcare industry because they wanted it to be noted that the commission itself does have that long-term understanding of the healthcare market. And they believe that because of that and the evidence that they're presenting, that it supports the final rule and its application to the healthcare industry. And in the comments, actually, or in the rule itself, they do talk about the fact that many organizations and commenters wrote in specifically asking the FTC to carve out the healthcare industry as a whole and say it is not going to apply because they said it was so uniquely situated that it should not apply, but they did not adopt that exception at all and specifically said that it is not uniquely situated that it would justify an exception. And they go through a lot of the costs and benefits of the implementation of this rule, ultimately also saying that non-competes themselves do increase healthcare costs, but find that there will be, some collateral consequences as far as cost, but that the benefits themselves really clearly outweigh the costs associated there.
Yeah, I think that's such a great point. I'm really glad that they hit on it specifically in the rule because there's certainly a lot of employers and whether that's practices owned by private equity or health systems, right, that are a little bit up in arms on this. I mean, we've already had clients come to us saying our employer came out and told us this rule doesn't apply to them, which I think is a fairly defensive, action. But the commission saying, yeah, we understand that this might hurt for a little bit, but the benefits outweigh the costs on it. I think that's great. So, you talked about all the different references, and I jumped ahead slides here, so people might have seen that by accident. But walk us through this one. I think this is almost a perfect example of why this is needed for physicians.
Yeah, absolutely. And so when the FTC opened up the rule originally last April, they asked for comments on their original rule to kind of inform this final rule that they came out with this April. And they received thousands of healthcare workers submitted comments. And as Kyle noted, this one specifically where this physician writes in saying that they've been under a non-compete for 11 years. And because of that, they're essentially geographically restricted. restricted because they monetarily and time, they aren't able to kind of go out and find another position. And if you have the time, there are a lot of very interesting comments from healthcare providers in there. I'm sure you either are or know someone who's been in that position. But the FTC also talks about in there that in an already stressful situation, right? That non-competes can make it harder for to leave jobs with sometimes some unsustainable demands of healthcare providers, and so then they can feel trapped there. And similarly, limiting your ability to earn for yourself and also career trajectory. For example, this one comment here saying, I haven't had a raise in 6 years because they, ultimately, kind of negotiations come down to what leverage each side has, and they specifically talk about how their bargaining position is limited because of that. And so the comments themselves from the providers, I think, were really also beneficial in showing just how wide-reaching and detrimental these restrictions are on providers.
Yeah, no, there's certainly, I mean, in the line of work that we're in, right, of representing physicians in their contract negotiations all day, there's something that we hate, right? I mean, they remove leverage, they, make families move, they take away your negotiating power in renegotiation. So all of that I think understand are bad. And I'm looking at the questions coming in, and you guys are teeing up the next couple slides. So there's a distinction in the rule, right, of does this apply to only for-profit entities? Does it apply to nonprofit entities, academic centers, things like that? And so with that, Bryce, I'm going to let you talk about for-profit entities and the application under that scenario.
Yeah. So this is a lot more clean cut compared to nonprofit entities, right? The for-profits, it's your tenants, it's your HCAs, right? It's UHS, it's those types of entities, large for-profit hospitals, including, right, even private physician groups or your private equity entities as well. And so this rule then, it falls under, or the FTC would have authority, I mean, assuming that, the lawsuits and so on, but this rule is applying to for-profit entities. We'll talk about how that affects nonprofits as well, but for purposes of this discussion too, it's for-profit entities, it's more black and white as to whether or not this would apply to them.
Right. And some of the questions that are coming in are around the salary number that was thrown out, the 150,000. And so let's talk about if you're in a for-profit entity and there's a ban on non-competes, that there are exceptions to that rule. So this is an exception saying the non-compete is allowed in this situation. So Bryce, tell us about that.
Yeah. So for the senior executive exception, I think a clear delineation to make for this is the fact that the senior executive exception would not work retroactively, right? So this rule would apply to senior executives if that non-compete were entered into after the effective date. But for those non-competes that were entered into prior to that effective date, the senior executive exception would apply, therefore making that non-compete still potentially enforceable. And there's two elements for what the FTC stated for a senior executive. The first one stating whether or not they have a policy-making decision, right? This is your C-suites, right? This is your CEOs, medical directors, right? Can fall under this as well. But they have a rule stating that it's the final authority to make policy decisions that control significant aspects of a business entity, does not include authority limited to advising or exerting influence over such policy decisions, right? And so for purposes of physicians, most is our opinion that it would not apply, right? That this policy-making decision would not apply to most physicians. It becomes a lot more likely it would apply for those having more administrative duties and actual actions over these policies. The second aspect of this would be the salary aspect, where that senior executive would also have to make more than $151,164 annually. Now, they do have this written out where if a senior executive were to work for half a year, they were to start at, let's just say June or July, and they were making $100,000 right per year, then this would be annualized out, and it would apply for the entire year. They would look at it and say that was 200,000. But that's where that compensation aspect comes into play, would be just for purposes of the senior executive exception.
Yeah, and I think it's great because there's a lot of questions, and we've been fielding them from our clients on, you know, if I'm in a for-profit entity like an HCA that you referenced, and if I sit on committees, if I have some managerial role, it's great that in the rule itself, there's these exceptions talking about a head of a hospital surgery practice doesn't count, right? That's not enough. If you run an internal medicine practice, it's part of a hospital system. Not enough unless you're actually making decisions that affect the business as a whole, not just your division. And so if you are in private practice, if you own, 10, 15, 20%, for example, and you have the ability to influence policy, I think that's, a lot of this is going to be fact and circumstances, right, of your situation. So I don't think you can take away anything directly from this, but I do think it gives you some railroad tracks to analyze, right, your situation under, and know that it is both prongs are required. It's not just that you earn more than 151, it's that you also have this policymaking authority. And again, Bryce talked about the distinction between retroactiveness on this versus new agreements. So there are a couple other exceptions that I want to make sure we get to, and then we're going to talk about nonprofit entities next. So there's two more exceptions here. Bryce, walk us through those.
Yeah, so the two other exceptions would be sale of a practice, right? So if there's a bona fide sale of a business, that this rule would not apply to those non-competes. That includes, right, an interest in a practice. They did not put a specific number on how much would have to be sold, right? It just has to be bona fide sale of a business. And so arm's length transactions, those types of ideas. The other would be how this rule does not affect current litigation, right? So if litigation happened prior to or started prior to the effective date of the ban, this rule would not then apply to that circumstance.
Right. So maybe the one takeaway, right, is if you're trying to ride this out and wait, you don't want to get stuck in litigation on your non-compete right now, right? Because if that's happening, the rule won't apply to it. But it may apply obviously in September or later once it clears and is in effect. Okay. So let's now talk about, so that was all for profit. Let's now talk about nonprofit entities and some of the conversations that happened around those. Lauren, you want to walk us through that?
Yeah, absolutely. And I'm sure this is, personal for many of you as, 58% of hospitals claim tax exempt status, which is that 501c3 status through the IRS or other, designation. And the act itself does exclude from the definition a corporation of any entity that is not organized to carry on business for its own profit or that of its members. Now, they do talk, though, specifically about the fact that there is, that 501c3 status or tax exempt status is not dispositive, right? So it is not on its face. If they look at that, it is not explicitly excluded. Now, the rule itself that they talk about, it would be looked at on they would apply a two-pronged test essentially. And there's precedent for that because they have seen nonprofit hospitals that have actually been found to be carrying on a profit for their members. And this quote here that's pulled where they talk about the hospitals are operating to maximize profits, pay multi-million-dollar salaries to executives, aggressive collection tactics. All of those things were found then for it to be a for-profit entity, even though kind of highlighting that tax exempt status is not the requirement there. Now, many of the comments that the FTC references, they do talk about the fact that they argue that they erroneously assume that it's not going to apply to nonprofits, but they do specifically go in and talk about the fact that some portion of that nonprofit, that 58% healthcare organization that is tax exempt, will fall into their jurisdiction. Because of that, under their final rule. Now, they do also acknowledge it may not reach every facet of the healthcare industry because of the limits of the FTC's jurisdiction. But on the same hand, they do say that they think all non-competes are an unfair method of competition. And so, they're making it clear how they feel about it, but ultimately the FTC's jurisdiction, they're saying that while some fall in, they can't definitively say that all or none will.
Yeah, and I think that's, going to cause a lot of issues, right? I mean, so if most of physicians are in this nonprofit entity at this point in time, because most are employed, and then in that employed bucket, most are in a nonprofit setting. If their position is, some of you, right, are under this rule and some of you aren't, but we're not going to tell you which ones are. We know what the employer's positions are going to be, right? We're not one of those that are operating like this, and so we get to keep our status. So again, it's going to be a very fact and circumstances analysis, right? Not only for you, but probably for most physicians at your organization. If indeed your organization is going to make a decision on this, that they're not going to enforce their non-competes, Zach, do you want to talk about how that notice is going to come out?
Yeah, so within the rule, there's actually a notice section that talks about when the employer must provide notice. And it states that notice is required no later than the effective date of the rule. As I mentioned, that effective date is going to be 120 days from publication. And right now, publication is set for May 7th, which gives you effective date of September 4th, 2024. And within the rule, the FTC does provide a little template, as you can see, that gives kind of a model language that the employer must provide to you. And it goes into detail about how that form of notice must be provided, and as I mentioned, when it must be provided.
Perfect. Okay, so those are kind of the main points of the rule. There are a few other things that are discussed, by this rule of what applies, what doesn't apply. I want to kind of walk through some of those more frequently asked questions, and some of these are actually being posed right now in the Q&A, so this will be hopefully good for that. Bryce, you want to hit on some of these?
Yeah, absolutely. So some of the questions we've received recently are, does this apply, number one, to outside activities, right? Moonlighting. This only applies for post-termination of the agreement. And so restrictions on your ability to do or render services outside of your agreement while you're still employed, this rule would not apply to those restrictions. Next one, regarding whether or not it applies if a physician is hired by a staffing firm. The final rule, FTC kept it as broad as they can. They're stating that, yes, it would cover workers who are hired by one party, but then work for another party. And the similar type of idea, keeping it as broad as possible, they are also including independent contractors. They use the word term rather than the word employee to keep this as broad as possible, but they are including independent contractors in this decision. This now in regard to non-solicitation, non-disclosures, including non-disparagements, confidentiality statements, all of those would not be affected by this ruling. This is only preventing non-compete agreements, and so those non-solicitations and non-disclosures would still be applicable in this situation. And then finally, it doesn't really matter where that non-compete is going to be listed. Right, if it's in a handbook, policy, or if it's explicitly stated in the contract, that final rule is going to apply wherever that may be placed.
Perfect. Okay. So the last thing I want to talk about before we turn it over to questions, and you guys are doing a great job of plugging them in already in the Q&A. You can use the Q&A or the chat feature. Just a few tips for you on how does this affect you today? As we talked about, your action items are, one, it's not applicable yet. Okay, so September 4th is the earliest possible date that your non-compete could be, removed, depending on your situation. you need to make sure you're reviewing your document and understanding your employer type, whether it's for-profit or nonprofit, and whether it falls into those gray areas where it may be considered a for-profit entity. You need to check the exceptions that Bryce touched on earlier to make sure even if you're in a for-profit setting where you think it's getting wiped out, that you don't have an exception over top of you. Make sure you're looking for that notice that should be coming out. If you don't get the notice, pretty good chances are that your employer thinks that they can continue to enforce this. So take a look out for that. And then finally, make sure you're staying up to date and following the news on this topic. You can certainly follow our blog. There's plenty of people talking about it, not just us. But as these lawsuits roll through, that deadline certainly most likely will get pushed back some. How far we, obviously don't know. But if you need a quick overview or a cheat sheet on this, we did create one for you. And so there's a link to our blog on this if you haven't seen it already. It's also listed here for you. And we are going to be, I think, putting this webinar out in a recording so you can go take a look at it. But pretty much everything that we've touched on, we tried to boil down to one screen for you here. So you can utilize that as a reference point moving forward, or to give to colleagues if they have questions on it if they couldn't attend. So with that, I am going to turn it over to questions. We will try to answer those the best we can in this setting. We'll take them in kind of maybe a round robin fashion here. I'm just going to start reading off the first couple that came in. Nonprofit hospitals, we already talked about, so I'm going to skip that one. As a general rule, for those of you that may not have heard it, the FTC cannot regulate nonprofits. However, they specifically said for hospitals that some of those look like for-profit entities. And so it's a maybe on that category of whether or not your non-compete is going to be wiped out. Looking for guidance for scenarios where people would renew their contracts, before this goes into place in September, and how we should navigate this discussion. So I'm going to turn that one maybe to Lauren. If somebody's going through a contract negotiation now, or reviewing, or renewing their contract, what's your advice?
Sure. And again, depending on the nature of the employer, that would inform you. I think it's worth, even if you're at a not-for-profit, to say, listen, there is a federal ban on this, whether you agree or disagree with how that's going to play out. Obviously, the spirit of a non-compete has been, in that sense, looked upon negatively, to put it lightly. But from that perspective, I would say use it as a bargaining point and say you'd like to just get it removed. In a not-for-profit situation. Same with the for-profit situation. It's just that you have a better argument there, right? As of right now, there is nothing that is going to stop the rule from going into place in September. And when it does, anybody in a for-profit situation, except for those few exceptions, will not have a non-compete able to be enforced against them, whether or not it's in their current contract that they just negotiated or negotiated 10 years ago. But there's also the very large likelihood that there's going to be something that either reduces the effect, pauses it, potentially takes away the rule altogether. And so I think that you want to prepare yourself if that were to happen, and try to negotiate the non-compete out. If it's a hard and fast no, try and limit the consequences of the non-compete in the sense of either geographic, distance, location, years, the time as well. So I would say, depending on, you could hope it goes through as it is planning in September, but ultimately, hope for the best, but prepare for the worst.
Yeah, good advice. I'm scrolling through these. There's a few of them that are talking about the $150,000 number, and we hit on that. But if you missed it, the specific question is let's say I'm an associate, so I'm in a for-profit entity. I'm not a partner yet, but I like most physicians make more than $150,000. Can they still enforce the non-compete on me? Zach, do you want to take that one?
Yeah, can you, which question were you looking at again?
It's about halfway down. It's not the next one. It's talking about if you're an associate, not yet a partner in a for-profit entity, but you clearly make more than $150,000. whether or not the exception applies where they can still enforce the non-compete on you.
I would say it depends on that exception and what is considered a policymaking position. And, it would depend on the rule and whether you fall under that exception and whether you qualify as listed in the rule as a policy making position. But if you do not fall under that position, then this still would apply to you, and the FTC ban would be enforceable, and you would not be subject to the non-compete.
Right. Yeah, I think it's so the hard part about all of these exceptions, and just even the for-profit, nonprofit distinction is that it's going to be so fact and circumstances, right, related. Hopefully, if you're just an associate, right, you're not going to be in a position of controlling the entity. So, our guess would be is that it would lean towards the direction of not falling under the exception. And there's a lot of double negatives here, but not falling under the exception means that your non-compete gets wiped out, right? So again, it would depend, right? But hopefully you'd be on the side of having some free agency there. Okay. Another question in here, about maybe a fourth of the way down is a 15% physician owner of a private practice group still subject to this new rule? Would they be considered a senior executive because they have that significant policy-making decision? Bryce, your thoughts on that?
Yeah, so it comes down to then the sale of the business, I think is an easy way of looking at this, where that 15% sale, if you were to leave at that point, would fall then under the exception to the rule. And so therefore, the private sale or the sale of the business there, whether it's 15%, 50%, 5%, right? As long as it's a bona fide transaction, that the non-compete rule would then have an exception to that.
Yeah, and I think anybody who's in private practice, if you're an owner and you're going to leave, most of your operating documents have a forced sale back, right? A transferability component to it where you're going to be making a sale. So not only are you in the policy-making position, right, exception, but you're also in the sale of a business exception. And so I think it's really unlikely that this wouldn't apply to you in that setting. Again, we can't tell you for sure, but I think it's most likely that the exceptions would not apply in that situation. Okay. We didn't talk about this specifically. One of the comments or one of the slides did have this on there, though, that the nonprofit component of 58% of the hospitals, there's also some discussion around governmental organizations, right, and state-owned hospitals. Does the FTC have authority over those? Lauren, you want to touch on that quick?
Sure. Yeah, it sort of depends. They talk about the fact as to whether or not they can rule on a state action, right, is what the FTC rule gets into. And it's similar to the not-for-profit situation where they have essentially said they would be looking at it a case-by-case basis. So I know that it's a little bit more of a gray area as well, but they did discuss that in that sense. So another situation where they've acknowledged that in the healthcare industry is something that we commonly see. So from that perspective, it was definitely something that was considered.
Yeah. I mean, generally the FTC can't govern, right, those entities. However, if those entities are acting like, right, a for-profit, they can pull it back in. So, okay. A couple other ones on here. One of the questions is around if you're under a locum contract, right, and they often have non-competes in those agreements. We did talk about that. The FTC talked about that in the ruling as far as staffing agencies. Bryce, you wanna hit on that one?
Yeah, they called that out as well, like you had mentioned, staffing agencies in their comments, and that would be the rule would be then applicable to this, so long as you're doing work for another. And so a lot of those tend to be, right, facility-based type non-competes where you can't work for them or cut them out, right, cut out the middle guy. But this rule would then apply to those restrictive covenants, so there's non-competes as well.
I'm bouncing around. Melissa, I know you're trying to mark these off as far as the ones that I've answered and that we've answered as a team here. A lot of them are duplicative. So if I'm not answering yours specifically, it's because I think we've already touched on it. There is a more of a, I think, a comment than a question, which I like. Is there really a possibility that the nonprofit hospitals will voluntarily give up their non-competes, seeing how hard they have pushed to enforce them, even in small rural areas? Is it hard to consider that they would voluntarily give those up, even though it's the right thing to do? What do you guys think? Do you think any employers are going to voluntarily waive their non-competes? Anybody on that one. I'm curious on your thoughts on this. Lauren?
Yeah, I think they're going to hold on to it with a death grip. Unfortunately, the way that they frankly do now, right? It gives them a lot of ability to kind of monopolize the marketplace. Now, having said that, though, let's say somebody brings an enforcement action where they think this is a not-for-profit organization, or they think it's a for-profit organization, right? Are they really going to continue with that litigation, or with the potential to be seen as a for-profit entity instead of a not-for-profit? Is the juice worth the squeeze there for them? I would argue not. But and on the other hand, I think that if this were from another perspective, as far as public policy, right, there's a literal federal ban on non-competes and these organizations wanting to enforce them. And so I think that, the tide is turning in that aspect. But I will say, even just anecdotally, in the past week since this came out in conversations with employers, is they certainly are clinging to that nonprofit status pretty white knuckle.
I think it possibly could be a domino effect, right? I don't think any of them will want to consider themselves under this viewpoint just because they have that not-for-profit status. I think if a precedent is established, I think there's a higher likelihood that those not-for-profit businesses that are really acting as for-profit will start to be a little more wary as to whether or not they want to enforce those non-competes. But I do think that precedent is going to have to be established in order for a lot of these not-for-profits to somewhat give up on their non-competes.
Yeah, I think it's interesting. So I'll give you my take on this. Is I do think there's maybe competing interests to some extent. So if you don't waive your non-compete and you're taking the strong position that you're a, not-for-profit hospital, that comes with benefits, obviously, with the IRS. It also allows your physicians to qualify for public student loan forgiveness, which a lot of physicians like and need, right? And so I think if we're going to challenge the nonprofit status to get our non-compete wiped out, we've got to be ready then to say, okay, I no longer qualify for PSLF, which maybe is not an issue, but it certainly is an issue on recruitment and the younger physicians coming in. I also would wonder if the organizations themselves would value the nonprofit status so much that they want to waive them before there's a DEC action or a lawsuit filed that challenges it, and then they lose it entirely, right? And so it could be, on both sides, the physicians and the organizations are going to have to decide how much of the roll of the dice or the Russian roulette they want to play, on this, because there's pros and cons, on both sides of it. Although I think the biggest pro is, let's get rid of these things. Let's let the free market decide what you guys are worth, force entities to compete, and to see how that all shakes out. So that's my take on it. But I'll lean with Lauren. I think they're going to hold on to these things until somebody forces them not to. Okay, Melissa, I'm going to have you. One of the questions is a link to the cheat sheet. So that's on our blog on resolve.com. I will have Melissa plug that into the chat component on this, but you can also just go to resolve.com, go to the blog. I think it's the first article that's on there, and you'll be able to have that image and also just a quick overview of that. Okay, the next question that I'm going to get to is, how long after the sale of the practice are you bound by a non-compete clause? So let's say you fall underneath this exception where the FTC rule does not apply to you. You've got a non-compete. How long are you bound by that? Zach, I'm going to let you tackle that one. It's kind of a trick question, actually.
Yeah, so it would come down to the terms of your current agreement. And you would have to look at your current contract and review that and see what the terms say.
Yeah. So contractually, there's no there's no mandate on how long, non-competes can be post termination. Some states, right? Some state laws say that, they can only be 2 years, right? That type of thing. But if you're not in one of those states that has a hard rule, it's whatever you signed off on, all right, when that contract got put in place. So, okay. Other questions on, I think just personal situations. If I've got a 2-year non-compete and 15 miles, is that enforceable or is it not? If let's assume the FTC ban is just wiped out, right? Meaning the lawsuits win, the rules today are still in effect, right? A year from now, non-competes in general are going to be enforced if they're reasonable. If they're not reasonable, that they've shouldn't be applied. And so with that question, with that question on the 2-year and 15 miles, it really depends on where you're located, what your specialty is. There's a lot of facts and again circumstances that go into that. 2 years probably is okay. I mean, we usually see 1 to 3 years, and 2 kind of hits that right in the middle. 15 miles, the more densely populated the area, the worse that sounds. If you're in a rural area and it's 15 miles, it's probably okay. But you'll just have to check, I guess, and kind of wait and see and decide how hard you want to push on that. Okay. I'm currently a partner. This is the very last one in the Q&A. I'm currently a partner. I own a third, but I'm selling my shares and transitioning to an employee. As an employee of a private practice, will the ban apply to me? As an employee specifically, I'm going to take this one. As an employee specifically, the ban should apply to you, right? Meaning in your employment contract, there should not be a non-compete. My question back to you would be to have you check on is whether or not when you sell that interest, or as a partner right now, you would fall underneath the exceptions where they could still enforce the non-compete as either a senior executive or as selling your shares. So I would just say be careful on that. But as an employee specifically, if the ban stays in place, you should be okay. Okay. If it all goes through, fingers crossed, how would this affect state laws like Georgia that specifically allow for non-competes? Would a federal rule override a state law? Lauren, you want to give your thoughts on that?
Sure. Yeah, so the rule of the supremacy clause says that federal law would be the supreme law of the land. And so in a situation where they conflicted, the federal rule would be the winner there. So even if a state law would allow a non-compete, the federal rule would win there.
Yeah, no, it's just classic supremacy. So if for some reason, right, the state has better, right, rules than this, the state
Right.
law would win. Most states don't have better rules than this where they just wipe them out entirely. So you'd be defaulting back to the federal rule. Okay, my employer specifically refrained from saying non-compete. Instead, they called it a restrictive covenant. Will this rule apply to this? It's essentially the same thing on just a different term. Bryce, I think you talked on that slide. You want to give us your thoughts on that?
Yeah, it's not so much how they call it, it's more so what it does. And so if that is a restriction on you competing with them, right? They're rendering healthcare services, you're trying to render healthcare services, and that's what they're restricting, right? That's what this rule is applying to. And so regardless of how they frame that, if it's a non-compete, right, effectively a non-compete, it is going to apply even if they don't call that.
Okay, another question or two, I think, on this topic. If we think we're in a gray area, right, meaning we think we are in this maybe senior executive spot, or we're in a healthcare system that may or may not be, for profit or nonprofit, who do we consult with this? Is it Resolve, right? Is it anybody else? I think we are a good spot to start. So we review thousands of physician agreements a year, right? We interact with healthcare systems all day, every day, and provide, counsel and guidance to physicians. So I think if you have questions on this as a starting point, we're very good. if you are going to go through litigation on this, obviously we're not, going to be doing that type of work. We're going to be helping you and connect with other experts that are doing employment litigation and things like that. So I would say we're as good a spot as any to start with to answer those questions. And it'll just be depending on your circumstance on how far we can, kind of take you through that process.
And don't start that litigation process before September.
Yeah, that's exactly right. Yep. Okay, here's another one on my non-compete is 50 miles or has a 50-mile radius, and my new opportunity is at 49.85 miles pursuant to Google. After September, if this law goes into effect for nonprofit hospitals, can I go to the new place? Zach, what do you think about the 0.15 mile distinction?
Yes, after September, after the effective date, the non-compete would not be enforceable and you would be able to go there, assuming you don't fall under one of the exceptions.
Yeah, and I would just be, I mean, we get that question a lot, right? At least I do with clients of, I looked on Google and it's exactly 9 miles and my non-compete's 10. I just think you've got to be really careful on Google being right on that and making sure you're doing like as the crow flies versus driving directions, because that's a mistake people make all the time. Non-competes are drawn with a straight line. So for those of you that don't know that, it's not how the road gets you there. It's how a crow would fly. So be really, really careful if you're at 49.85, regardless of if the band's in place or if it's not in place. I just think you got to be certain on both of those things because it's really, really a kind of a hair that you're splitting there. Okay. I'm anticipating private practices might try to get around this by including in their contracts small amounts of equity, say 2%, not enough to play a significant role in decision making, but possibly enough to qualify for ownership to make the non-compete rule still applicable. How do we suggest navigating the situation? Yeah, I'll take this one. So I think there's going to be a lot of games that are played if this ban is in place, right? So I think there's going to be a ton of non-solicitation stuff that's pretty strong. I think there may be liquidated damages provisions that come in that they're going to try to enforce that say, if you leave us, right, well, there's no non-compete, go ahead, but you've got to make us a financial payment back, which I think begs the question, does that have the same effect as a non-compete, right, or not? I do think private practices may want to give some of that equity to initial hires to force that sale of a business exception to come in. I think even, for-profit systems may want to give titles out that make it look like you're a policy making, right, decision maker for certain items. So I think it's hard to guess at all the ways that legal on both sides of this will react. But the jobs of attorneys, right, are to get the best situation for their clients given the rules that are in effect. And I would certainly expect, health systems and, anyone, right, that's representing a physician practice to try to do the best they can for their side of the equation. I just think you've got to be really careful on your side, right? If you're that employee or you're that person coming in, you better know what you're signing and don't just anticipate that the rule now is in place. There's a ban and I can sign this and not have any repercussions from it. So I think that's a great question. And I think it opens up a whole Pandora's box of issues that we don't even know what they are yet because we don't know how creative counsel is going to get on this. Okay. I'm already left my practice and I'm waiting out a non-compete right now. After September, will my prior employer need to send me a notice? Lauren, what do you think on that?
Yes, they should. They're supposed to. Whether or not they will, I suppose is the question, but they are supposed to let you know that they will not be enforcing it.
Yeah, that's right. So everyone that is supposed to be waiving a non-compete is supposed to give that notice out. Zach talked on that slide, but it doesn't mean that they all will, right? I mean, we know that there's lots of rules that organizations don't follow, sometimes intentionally, right? Knowing that there's a penalty, they'll pay the penalty rather than give that out. Okay. Most recent one that came in says, I've got a non-compete at 10 miles, but the contract has been changed or has been changing verbally such now that my production is down and I'm the only one to see follow-up patients 2 days per week and limiting that number. I think if they're changing terms of your contract, it'd be a great time to have them invalidate the non-compete and take that out. So it doesn't necessarily mean based on that fact and circumstance that it is void, as of today. Certainly we know, we've said this a few times, but the FTC ban is not in effect today, right? So it's not a tomorrow type thing that you can walk to a new location. But if they're already changing terms, I would certainly encourage you to start to think about that now too. I know there's a lot left in here, but I actually think we've touched on almost all of these. Zach or Lauren, do you see any that are not duplicative?
I saw one that talked about notice, and if you haven't received it, what you should do.
Yeah.
And I would kind of reach out to the employer with that model, that template of language that they provide, and maybe have the employer sign a document stating that they will not enforce the non-compete. But that's probably what I would do if they haven't reached out and provided that notice.
Yeah, we actually have had a client request, right, that template that we showed you guys, that the employer sign off on that right today, even though it's not in effect today. And so I do think it's a fair request. If you're going to try to get them to waive it, there's now a template out there, right? It's approved by the FTC. Go get it, go use it, have them sign off on it if you can. I just think, like we've talked about before, I think it's going to be, most are going to hang on to it at least until the day before, right? So September 3rd, right? To see if there's litigation that pushes this thing back, because I don't think they're going to voluntarily just walk into this. Here's one. What have we seen as the most successful way in a contract negotiation to have a physician avoid entering into a non-compete cause? Specialty is addiction and forensic psychiatry. I would probably say that this is similar to any term that you want to have changed as far as, what's your best and most successful way to do that. You have to have leverage of some sort, right? You have to not be willing to take the job because there's another good one out there for you. Or you've got to have authority like this, right? Like some legal basis for why you can't. Either it's against state law, it's against the FTC rule. But I do think ultimately we see the most changes from clients on non-competes and compensation and anything else when you've got competing entities. And that's really what excites me the most about this rule, is that hopefully there is going to be competition and we're going to find out, exactly who values you and who the good organizations are, because you're going to have that free agency to be able to walk, back and forth. So that's my thought on that.
Yeah, and I think it's interesting too, because a lot of the comments that they received were talking about, well, it'll be difficult for us to retain providers, employees. And the FTC basically responds by saying, well, pay them better or give them better benefits, right? Like there are other ways to retain good talent that don't include a contractual obligation to stay. So, I think that they do in that sense also talk about that, right? That there are other options available. Whether or not they like those options, I suppose, is the question.
Mm-hmm. Okay, the last question here is, if it goes into effect, will it likely stay in place? Can litigation reverse it later? Is that likely to happen after the fact, or if litigation stops it, it would be likely before the 120 days? Well, like everything, right? I mean, rules can change. And so it doesn't mean that if it goes into effect, it's in effect forever. I do think, if I have a crystal ball, I do think it's going to get pushed back beyond that September date. I think this litigation will put, some type of injunction and stay on the rule until they get some of this sorted out. I've heard speculation that the FTC will walk back some of their position to a lesser effect to try to get it to be challenged less. Maybe. I think that's unlikely. I mean, I think they've taken a pretty strong position. I think they're going to have to see how this plays out. But it can change, right? I mean, it's 5 years from now it may be different, but I think any step in this direction is helpful. The FTC even referenced that specifically, that even if this only applies to, let's say, 30% of all the hospitals nationwide, that's still better than nothing, right? And so it doesn't have to be an all or nothing rule. We wish it was, but even if it's just on a portion of the market, that will, I think, insert competition, because if you have a choice, let's say you're moving to Denver, right? And you've got 10 potential employers in Denver and 4 of them don't have non-competes and 6 of them do. If I'm in that situation and I really have to be there, I'm probably going to work my way through the 4 that don't have non-competes, because if I make a mistake on it, I can just go to the next one, right? And if I don't like that employer, I can go to the third one. It'll be really tough, I think, for organizations that have non-competes to compete on attracting new talent. Now, it doesn't help you if you're already signed there, right? Obviously, that stinks, and you may have to ride out, some of that time period or geography. But I do think it's going to have implications, even if it does, have limited application. Okay, so I think those are all the questions. I am going to shut this off. I'm a big believer in, if we're here for an hour, let's get you guys back to your families and your nights and all that stuff. So we appreciate you guys stopping in. If you have other questions for us, you can certainly go to resolve.com. There's a chat feature there. We will try to answer those as quickly as we can. You can certainly create free accounts. You can certainly utilize our service if you'd like to as well to get more advice on this. And so we appreciate you stopping out tonight.